Me today in the audience might have learned a few things about what's on my CV from that introduction. So it's always great when we can help fill my mom in on what the crazy is that occupies my days, nights, and weekends. I am thrilled to be with you here today. It is really an honor, a privilege, and my pleasure. And so much so, it's absolutely the case that this is 2 years in a row that I have left Reagan with smoke flying from my heels in an effort to get here and to be with you. And it's in large part because of the audience for this particular event. My experience in engaging with a number of you here in the audience today has been that I have been educated, going from being the law professor who stands with certainty at the podium and conducts and instructs in terms of what the law is. I am learning from you what the technology is and whether or not the law that we have, whether or not the policy that we've long deployed is in fact fit for purpose. So ahead of my offering any formal thoughts or reflections, allow me to share an anticipated disclaimer. The remarks I'll share today are my own. They're not the views of my fellow commissioners or the commission staff, although I'm always hopeful that there's a common set of values and core principles that guides our collective aspirations for market integrity, market stability, and protection of customers, particularly the most vulnerable in our markets. If I were to offer a title for my remarks today, it's a continuing theme of the remarks I probably gave last year, and I describe the remarks as corporate governance reforms for crypto markets, DeFi markets, digital asset markets, or some combination of all of the above. Undoubtedly, many of you recently saw the CFTC's announcement of a resolution in litigation that involved Binance, its founder, CZ, and its chief compliance officer, Sam Lin. The $4.35 billion penalty captured significant media coverage and headlines around the world, while the size of the penalty and the coordination of law enforcement authorities, the CFTC, the U.S. Attorney's Office, Treasury and FinCEN, and OFAC, imposing a coordinated settlement on defendants, presents a striking portrait. These accomplishments should not overshadow one critical legal issue highlighted in the Binance litigation and in another set of matters involving 3 DeFi platforms initiated by the Commission in September. In each of these matters, it's worth noting that the Commission did not allege that the defendants engaged in fraud or any other type of misconduct. Rather, the allegations reflect the Commission's authority to ensure compliance with Commission regulations. Let me give you a little bit of background that I can't help but to share because I do come to this from law teaching. What is the authority of the CFTC anyway in the context of these markets? Well, Section 6 of the Commodities Exchange Act and Part 180 of our regulation empowers the CFTC to engage with broad and far-reaching authority in prosecuting fraud or market manipulation in the sale of a commodity in interstate commerce. This would include any digital asset described or defined as a digital asset commodity. To date, the CFTC has initiated 134 enforcement actions against actors in the digital market ecosystem. A significant majority of these cases allege that market participants engaged in fraud or another type of misconduct. I've said extensively, and I won't belabor the point here, that isn't every business. In fact, there are a number of businesses and entrepreneurs engaged in leveraging the significant benefits that these technologies might bring to our markets. The dilemma is the activity of these bad actors often overshadows the activities of entrepreneurs and developers, designers, coders, who are actually creating protocols and platforms that might potentially do some good. What I want to focus on today isn't the bad actors. It's the reality that there are regulated activities that are not solely confined to bad action or misconduct. In the enforcement action against Binance, the CFTC, as I said before, didn't allege acts of fraud or other misconduct. Instead, the complaint charged the defendants with offering and executing illegal off-exchange futures, options, and retail commodity transactions. It alleged that Binance failed to register as a futures commission merchant. That's an intermediary that facilitates the sale of futures contracts on a registered exchange, or as a designated contract market or swap execution facility. These are essentially the types of intermediaries that operate in organized traditional financial markets. In addition, and this is where I think we really want to focus our attention, particularly for folks who are CEOs, CFOs, CROs, COOs, CLOs. If you're in the C-suite of a business or developing a business yourself as the founder, the entrepreneur who's leading a project, you want solid and capable corporate governance oversight. And part of the charges against Binance directly alleged that Binance had failed to supervise the creation of certain types of compliance programs that you all are deeply familiar with by now. Customer identification programs, know your customer procedures, anti-money laundering programs, and activities that might evade Bank Secrecy Act regulations. The reason I'm focused so carefully on the question of what the charges were in Binance is because in large part, when we talk at the CFTC about enforcement actions, folks are thinking typically about fraud, and for good reason. Over the last year, the CFTC announced a total of 96 enforcement actions, bringing the total number of enforcement actions last year 20 years higher than the previous fiscal year. The categories of enforcement actions included manipulative conduct, false reporting, spoofing, supervision, failure to supervise, financial integrity and business conduct, illegal off-exchange contracts, trade practice violations such as wash trades, fictitious trading, violations of position limits, reporting and recording violations, misappropriation, and statutory disqualification as well as fraud. The category that typically, as I mentioned before, gets the most attention is fraud. During the last fiscal year, 49% of all enforcement actions in the digital asset space alleged fraud with respect to those transactions. I could describe for you several case studies, and if I describe for you the details of the case studies, you would find everything that I'm describing to be factually accurate. I talk about FTX. Roughly a little over a year ago today, we were talking exclusively and extensively about what was happening at FTX. But ahead of that, we were thoughtful and considering what happened at Celsius or Voyager. If we think about these three case studies, one thing we might observe in considering these cases versus others is that all but one of the firms I've described, Binance being the exclusion in the context of the cases described so far, the CFTC initiated enforcement action against a business that was already seeking bankruptcy protection. In other words, the deeply regrettable and unfortunate outcomes for customers and creditors of these businesses, customers and creditors who may never receive full restitution for their deposits, was already determined by the time the CFTC actions were brought against the firms. Second, in multiple instances, transparency or the lack of transparency or any visibility into the business operations and risk management practices of the firms involved amplified customer losses and market disruption. Finally, for a number of these firms, an imperial CEO with unbridled authority operated without effective checks and balances. And here's where I focus my attention, and we could also draw our attention to the Binance settlement. Several corporate governance measures were missing from the perspective of those of us who sit regularly supervising these types of firms. These corporate governance measures include ensuring qualified, capable, independent directors, or at least directors are serving at the helm of the institution, that there are internal controls, audited financial statements, an independent auditor, and extensive examinations of system safeguards and segregation of customer funds. Left to my own devices, I could talk for hours about that very last piece, mostly because it rings so true to me, and I'm so deeply concerned when I discover that dear friends have invested in firms or entrusted funds to firms that fail. As we think about these cases, I guess a few things I say before I close out my remarks and happily open up the floor to Q&A, first with Georgia and anyone else who wants to share a question. One might be skeptical about the idea that the statutes and regulations that the CFTC uses are in fact applicable in the context of the contracts that Binance, and I mentioned 3 DeFi platforms that we brought an enforcement action against earlier, apply. How do we know, in fact, that the types of contracts, the types of transactions, in fact, smart contracts, one could argue, were ever meant to be subject to CFTC jurisdiction and oversight? Well, you might guess from everything I've said so far, and potentially my tone, that I believe it's very clear, in fact, that in a number of contexts, existing regulation applies and may actually be useful in the context of even the most innovative emerging technologies. In the context of the contracts that the 3 DeFi protocols that we brought a case against in September mentioned, the contracts themselves are described by the platform as perpetual contracts that facilitate the sale of essentially derivatives of commodities. In that context, what we have to think carefully about is how we apply the law and the extent to which there is need to refine or focus our attention on aspects or attributes of the technologies that we're regulating to ensure that we can continue to foster responsible innovation. I'd offer up the following reflections very quickly regarding the crises that I mentioned earlier and the potential for corporate governance reforms to be helpful. I believe that crises, and I said this earlier this year, create catastrophic costs for customers, creditors, investors, markets, and the domestic and global economy. I feel strongly that creating effective corporate governance and risk management controls can help to avoid these failures. These are checks and balances that will help to ensure the health and longevity of firms operating in the crypto or DeFi space, as CeFi or DeFi platforms, across the financial services sector, and to be quite honestly, these are good vitamins and vegetables for almost any business operating in any space. Finally, I'd point out that all too often, the corporate governance, compliance, and risk management programs that I'm suggesting were not adopted or are only imposed upon firms long after a bankruptcy process or some type of failure has happened. So fast forward, or at least rewind, to the discussion I offered at the outset of my remarks, that Binance, in the resolution that we entered into with them last week, has agreed on its own to change certain aspects of how its corporate governance works. I believe this is a very important illustration for all businesses operating in the space that might ultimately be subject to our jurisdiction. The time is now to begin to adopt the reforms that ultimately are part of the regulated markets. As part of the resolution with Binance, Binance has agreed to maintain 3 independent members of its board of directors. You may even have heard or seen news regarding CZ's response himself as co-founder with respect to his own service on the board of directors in recent days on the front page of any number of newspapers. In addition, Binance has agreed to stand up a number of committees on the board of directors, including a compliance and auditing committee. Binance has also agreed in the settlement to significant improvements of its compliance program. Binance will now require all accounts to complete an onboarding program. It will not permit sub-accounts to operate without also undergoing the same Know Your Customer procedures. Binance also agreed to ensure that any registered accounts are subject to Know Your Customer and anti-money laundering onboarding. And to ensure that Binance would not turn a blind eye in the context of any derivatives customers located in the United States, Binance agreed to operate a nationality of business entity checklist. The board independence, KYC, and AML measures adopted at Binance are illustrative, an example for its business of some of the good health measures that needed to be undertaken according to our regulations. Think about the business that you work for. What are the good health measures that you would propose sitting in the seat of the CEO, the CCO, the CRO, or the CLO of the business that you're supporting right now? I've spent significant time over the last several years calling for legislation and hoping that Congress will resolve open questions regarding spot market oversight for digital assets. As we await Congress's action, eagerly anticipating a resolution to these questions, I believe there are actions that the CFTC and other regulators can take now. I also believe that a significant thrust of what has to be accomplished rests with each of you in this room. To be successful, any blockchain or distributed digital ledger project, any business that adopts this technology will have to find a way to articulate how it fits in the broadest ecosystem of our economy and our society. I'm very excited to hear the ideas that you are generating for how you'll ensure the integrity of the sector of the industries that you're operating in, and how we might borrow from the ideas that you're articulating to help refine and create regulation that's effective to ensure market integrity, market stability, and customer protection. Thanks so much for inviting me this afternoon. It's tremendously my pleasure to be with you. I look forward to your questions.
Woo, how about it? You've got my vote, 100%.
Definitely not running for office.
First of all, I just want to say how honored I am to have gotten this gig.
Oh my goodness.
I saw you speak earlier this year at Fordham Law, and you knocked my socks off.
Aww.
So really looking forward to this discussion. Also, I might take our questions out of order a little bit.
Whatever you want to cover.
Just picking up because, you left off with Binance, and I know a lot of us in this room have some questions. We've seen the great work that has taken place, but with respect to the plea agreement, I can see that there is the monitor that will be there to be managing all of the AML KYC elements, but what about all the other elements that you mentioned with respect to the independent directors and all of the other components that we would see with good corporate hygiene?
So this is a brilliant question, in large part because one thing I'll share with you that I'm hoping that I can help you to fully embrace is that typically for financial markets, the first line of defense for compliance with regulation is the firm. We're regularly entrusting that firms, for their own reputational benefit, will police within their own house. And that also they're thoughtful about the extent to which their engagement with others will enhance or, in some context, diminish their own reputation in the market. Right? We presume in the financial market space, in large part, that your word is your bond. And for many years, in fact, I'll offer a personal anecdote if I might. I graduated college. In fact, I'll go back a little further. My senior year in college, I was applying to law school or studying for the LSAT. And my roommate said, "Are you sure you want to go right to law school?" And I thought, yeah, college has been some hard work. I went to Georgetown. It was just tough. It was so tough. We had a great time. And so she said, "Maybe you want a year off." And I thought, that's a good idea. A year off before law school. What should I do? And so she said, "If you're going to take a break and not work as hard, how about investment banking?" This is a true story. So we literally went to the library and began to research investment banking. This is especially hysterical because I've spent almost the majority of my career supporting large financial institutions and working at two of the most premier financial institutions in the world. But that having been said, this is really how I came to decide to apply for an analyst position at Goldman Sachs. And I mention that in large part because I joined Goldman Sachs the year after the firm went public, much to my chagrin. And what I'll tell you is, having read books about the history of the firm and the history of investment banking generally, there were moments in the history of the firm as a partnership where if something went wrong, every partner had to reach into their pocket and give out of their own profits or their own wealth to help secure the integrity of the firm. And it might not be that the firm had experienced some type of financial loss. It could simply have been that they had a customer that failed, or they were supported by a creditor who failed. And so to ensure the success of their firm and of the broader community, not just Goldman Sachs, but there are exceptional examples of JP Morgan as JP Morgan himself, James Pierpont Morgan, or other instances when long-term capital management failed, we saw sort of an intervention that was public and private sector coordinated. This is all to say that when I spend time with this industry, one of the things I really want to encourage is that you are the first line of defense at your firm, but you all together are a first line of defense for the industry. The more often you can police and root out misconduct, and that we can mitigate the extent to which the headlines that are capturing our attention are about marginal bad actors, and more often about successful, important projects that are contributing, then the more we're able to believe that the industry could take up legs and run, or take up wings and fly. One of the things I'd say about Binance is it's an illustration of things we knew were needed within firms, and we really are hopeful that people will begin to stand up on their own. The policing of that in the context of Binance will be really easily effective because of the binding court agreement. And typically that's not how we want things to work. We want folks to, on their own, generate successfully, effectively working compliance programs. But when that fails to happen, we will step in.
And specifically, it will be the court that's monitoring, or what U.S. regulatory body will be monitoring those functions?
So this is another great question, because recently, on a different matter that did in fact involve Goldman Sachs, I made a very public statement. In the context of that matter, for the financial product specific to the issue at hand, there's a long-standing expectation regarding compliance. And so, in part, one could say you could look at that litigation and understand that even the most storied businesses in financial markets with the longest history of operation in our country continue to experience compliance failures. So it's not the notion that there's a compliance failure that presents a problem. It's sort of how you resolve it. In the context of that particular matter with Goldman Sachs, one of the things we did was impose a monitor. And what I said in my statement publicly, which was picked up by the Wall Street Journal and a number of other outlets, is that one of the reasons having a monitor is so helpful is because we have limited resources. There are no folks at the CFTC who have capacity in this very moment to monitor exactly what is happening for each and every single compliance professional at each and every individual registered firm. In fact, going back to how we've managed policing markets, not only is the firm itself a first line of defense, typically in the context, for example, of futures markets, there is an organized quasi-governmental authority granted to, in the context of futures, the National Futures Association. Many of you who have worked in capital markets would be more familiar with FINRA. The idea is that the industry itself is engaged in some level of financing and facilitating oversight and surveillance to ensure only good actors are operating in markets. And so that second layer actually helps in many ways to assist with oversight of how compliance is working out at different firms. But once a monitor is imposed, the monitor is reporting out basically what the monitor has observed and telling the court whether or not the defendant is continuing to be in compliance. It's almost like a probation officer, maybe, right?
A little secret agent.
Yeah. Exactly. And the idea is to help have some focused eyes on issues that may be, in all honesty and fairness, not top of mind for the deeply engaged developer CEO or the exceptionally brilliant engineering CEO, right? We all have our strengths and limitations, and I think what we've seen as this industry is maturing in many ways is that folks are having to learn to have additional skill sets, right? So somebody who's got exceptional coding skills or someone who's tremendously capable in engineering and design is now having to learn the skill of managing others, of overseeing the development institution of compliance or cyber risk programs, all of which are for the betterment of the businesses you build. But it does require some growth, maybe personally for lots of management, folks in management, and then across the board for folks in the industry.
Thank you. So one thing that I've always loved about securities law is that it's a disclosure-based regime, right? So we don't tell people what you can and can't invest in. We just make sure that you have enough adequate information to make an informed decision for yourself. But with respect to the CFTC and certain products, maybe digital assets, are there some things that are just too complicated for people and we shouldn't let them make those decisions?
Yeah, so what happens, in fact, in capital markets is the average investor participating in, let's say, a retirement-based investing account, may not, him or herself, have the opportunity or time to go out and explore and examine and discover every intricacy or every detail about a business that he or she might want to invest in. So in the first instance, for many of you who are engaged in 401k accounts, for example, depending on the provider that your firm or company or corporation has adopted for purposes of facilitating those retirement accounts, you may have access to analyst research. If you're thoughtful about the broader, more direct or even firm level investments in capital markets, there may be an entire research team, right, focused on different strategies, investment strategies, long-term strategies, short-term strategies, strategies that are complex and relate or imagine correlations or relationships among multiple asset classes. So cross asset class product portfolio diversification. I'm sorry, I just had it.
Very complicated is the key. Extremely
I had to
complicated.
just get it out there as quickly as possible. Okay, so you got the idea. Whatever portfolio diversification strategy you've adopted, largely most of us are depending on either that research if you're really capable and engaged, and I'd love to talk to all of you who are reading equity research in your free time. Mostly, maybe you can teach me time management. But also there is, in fact, a market that just really helps us to discern what the analysts who are buying for institutional accounts think about certain types of assets. So this is where, from my perspective, and I'm a super economics of secondary market trading nerd. So what that means is I love the idea that we can understand the value of an asset based on where the price for that asset is landing in a market. And I love the idea that so many people around the world are absorbing so much information about the issuer of that security, that their decisions to purchase or sell, the amounts that they purchase or sell, directly impact how we all understand the value of that asset. So the economics of trading suggests that when you consolidate or aggregate trading on one or a few platforms, we're getting more price information. I describe it as price discovery is clearer. So we have greater price discovery. There's likely greater price accuracy. All of these benefits create economic efficiencies that make it so that it's easier for people to invest. It's cheaper for companies to seek and achieve investment from investors. And there are any number of knock-on benefits, economic benefits. I say all that to share that in the digital asset space, I think we're still maturing to a place where that level of transparency and visibility is established by private market participants, secondary market trading platforms. And I think that's a critical part of the maturing process of the ecosystem and of the future success or continuation of the market. So I'm really hopeful. I'm rooting for those of you who are designing and engaged in carefully effectuating surveillance on platforms, who are thoughtful about money, market makers and the inclusion of automated market making, especially in the DeFi space. For those of you who are engaged in thinking about conflicts of interest because you are facilitating trading on a platform and also contemporaneously trading yourself on the platform, I'm really encouraged by some of the things I've heard from any number of entrepreneurs who are working in the space. But I know that there's a long way to go because many of these issues are probably not the first issues that come to mind for the very brilliant developer or engineer or coder that I mentioned earlier. And these are critical issues for markets functioning with integrity. And if there is no market integrity, all of the benefits of price discovery and price accuracy quickly fall away.
Thank you. Thank you for that encouragement also. So everybody here knows that I don't like to be controversial. But I do feel, I have this feeling that
I love Gary.
I do have
I knew where
this,
she was going.
I do have this feeling, I have this feeling that there is a need for clarity in the industry. And I think, you know, this has been highlighted by the current district court split.
I think that's
the fact that we have two judges, both alike in dignity, both sitting in the Southern District where securities law is made, two cases, pretty much same facts and circumstances, diametrically opposed opinion. So Do you have any thoughts or suggestions on how we can get that clarity? And can the CFTC help us with that?
This is a great question, and I actually want to take one step back and just say, one direct path to that clarity certainly is legislative intervention for Congress to take steps to clarify how we might reconcile Section 2A1 of the Securities Act of 1933 and the definition of a security, more specifically applying the concept of an investment contract to innovative projects emerging in the digital asset ecosystem. And I think you guys have all the right folks here coming to this stage and speaking on this couch or at the podium over the course of today to really effectively begin to get that done. I would never get out over my skis and suggest I have any inside baseball styled information about what's happening on the Hill. I think I'll leave that to others. I will say, however, that with respect to the courts and the court decisions specifically, very fun fact, exceptionally nerdy, again, legal nerdy, not secondary markets, econ, benefits nerdy, but okay, and about Howey, the SEC versus Howey case. So in the 1940s, ahead of the court's decision in 1946, there were a number of cases making their way to the Supreme Court that involved agricultural initiatives in Florida or in the southeast region of the United States that were essentially parallel or identical to Howey. And so what I want you to appreciate just by my sharing that is that we've done this before. If we rely on the courts, we will get good guidance, I have no doubt, in due course, but it may not come instantly and there may not be immediate consensus. In fact, for every hot button topic that the US Supreme Court has ever addressed, it's typically the case that the court is addressing the issue because of divergent and equally plausible explanations for how to understand some measure of legislation or act undertaken. And so I think what can be helpful as we look at the landscape of both courts' upcoming and recent decisions and legislative action is to just trust that we've done this before. We do it very well. We have tons to celebrate in the context of how the institutions of our democracy and our financial markets and beyond really leave us in an exceptional place. So I feel very, very confident that this conversation, not just ours, but the broader conversation today, will come to a fantastic conclusion in due course.
Thank you so much, Commissioner,
Thank you.
Professor. This has been an education, and we're so grateful to have you here.
Thank you, Georgia.